Today, we will hear arguments in New York State Rifle and Pistol Association versus Brune. Counselors, please introduce yourselves.
Mr. Chief Justice, and may it please the court. I am Sana Goyle, and this is my partner, Emmy Medea, from the Baldwin School, and we are representing the NYSRPA as petitioners. We will now give a brief summary of our case.
Firstly, as proven by past precedents, concealed weapons are a right under the Second Amendment for the individual's protection. According to the Heller versus DC case, to read the amendment as limiting the rights to bear arms only to those in a governed military force would be to create exactly the type of state-sponsored force against which the amendment was meant to protect people. Knowing that, we can now state that each individual has the right to carry a gun to protect oneself and is not limited by militia.
Secondly, concealed weapons are condoned by the court for self-defense measures, which is at the core of the Second Amendment. Self-defense is essential to every human being, and the right must not be infringed. When a person is merely carrying a gun, not with the motive to harm anyone, but to protect oneself, it is considered self-defense. For these reasons, strict scrutiny applies because the government does not have a valid, significant reason for discriminating and taking away the people's self-defense when lawmakers have other options. In this case, New York should be tried under strict scrutiny because there are other solutions to protect the public's safety. Thus, New York's laws violate the Second Amendment.
Here are the facts of the case. New York law requires that if one were to carry a concealed firearm, the person must show a special need for self-protection. New York citizens Brandon Koch and Robert Nash disputed the requirement because they were denied their concealed carry applications. This claim was dismissed by the district court. However, the U.S. Court of Appeals for the Second Circuit stated otherwise. For these reasons, please rule for the petitioner. You're unmuted.
Excuse me, counselors. What does the Second Amendment protect?
The Amendment protects a user's self-defense, which dates back to the founding of this country.
Thank you. Why did the framers include the Second Amendment in the Bill of Rights?
As previously mentioned, the Second Amendment protects the right to self-defense, which is why it was included. Yes, a militia was mentioned in the Second Amendment, but it's not the reason behind the law, it's just a consequence of it.
Thank you. What are the limits of the Second Amendment's protection?
Limits of the Second Amendment are sensitive places such as government, schools, etc. And the user of the gun and the carrier of it has to be an upstanding citizen, for example, no felons or the mentally insane. But in this case, both of these restrictions don't apply because both men were able-bodied, mentally sane, and were not asking to go to any of these restricted places.
Thank you. What weapons does the term arms include?
It would include weapons that include some form of ammunition, such as guns, rifles, stun guns, pistols, etc.
Thank you. What is the difference, if any, between the verbs keep and bear?
The Second Amendment says citizens have the right to bear arms. Bear meaning they're able to carry it, not just keep, meaning to have in your possession. Bear means being able to carry and possess. Therefore, the NYSPRA had the right to conceal carry their weapons because under the Second Amendment, it stated that they're allowed to bear them.
Thank you. What is a militia and why did the framers refer to it in the Second Amendment?
A militia is a group of civilians/people that are able to fight whenever called upon. In some sense, the militia is the same as the people nowadays. It is a group of people bearing arms. A militia, if taken by historical context, is the American people bearing arms in order to protect themselves. Yes, the militia was mentioned in the Second Amendment, but it's just a consequence of people bearing arms. It doesn't limit the second clause of the amendment. Therefore, a militia, as should be considered now, is just a people's right to self-defense.
Thank you. How should courts determine if gun control regulations are considered long-standing?
Courts can determine that a gun control regulation is long-standing as long as it continues to protect its purpose and does not promote harm. Though guns have continued to evolve over time, this results in criminals as well owning these arms. For protection, the Second Amendment needs to continue to be updated and is therefore long-standing and still valid.
Thank you. What is strict scrutiny, intermediate scrutiny, and rational basis review?
Starting with strict scrutiny, strict scrutiny is applicable when every aspect of a law is contradicting the Constitution and is taking away the rights and discriminating against its citizens, and is considered unconstitutional and it's substantially burdening the core of a right, such as in this case of NYSPRA v. Bruin, where the New York laws oppose and directly conflicted with the Second Amendment. Secondly, intermediate scrutiny is to be used by the Supreme Court when a piece of legislature is passed with a somewhat burdening the core of a right. Compared to strict scrutiny, intermediate scrutiny is less of a burden. And finally, rational basis review is the normal standard of the review. This includes due process and equal protection questions. Rational basis review tests whether the law or a government interest is legitimate.
Thank you. Is there a difference between openly carrying and concealed carrying a firearm?
Well, no. Openly carrying a firearm and concealed carrying a firearm does not have a significant difference. This is because they are both essential to self-defense. If one is in danger, concealed carrying a firearm is very effective for some situations and will ultimately help the person who needs protection, while open carry will be effective for others. Therefore, in order to substantially protect oneself, both should be allowed. Remember, our biggest concern is self-defense, and to protect these people, both are required.
Thank you. How should the court consider the public safety implications of licenses to carry firearms?
The court should consider these as public safety is being well regulated through policing and other forces like that. The amendment itself doesn't go down if public safety is being at risk. For example, while public safety is considered in some locations, as we mentioned before, like government buildings and schools, as well as who's carrying the weapons, whether they're able-bodied or not, these two men in this case were not. So these restrictions do not apply to them. Yes, the government should control and regulate who is carrying the weapons, but in this case, both of the men demonstrated able cause, and they did not contradict any of these requirements.
Thank you. How would you have the court rule today?
We would have the court rule for the petitioner for self-defense and under strict scrutiny.
Thank you.
Thank you. Thank you.